Convicted crazy man Darrell Brooks is going to represent himself again. Yes, you heard me correctly. If you followed the original trial, you'll remember the chaos, shouting matches with the judge, bizarre legal theories, and a courtroom turned into a sad spectacle. Well, now he's doubling down, rejecting a court-appointed appellate lawyer and choosing to go it alone. But why would someone with no formal legal training try to take on a criminal appeal solo, especially when the stakes are so high? Well, because he's crazy. Knowing this, let's break down what this decision really means and whether it's like a strategy or a stunt or something else entirely. Darrell Brooks is a man who needs no introduction, seeing as he dominated online media for what felt like the longest 3 weeks of 2022. After driving his SUV through the Waukesha Christmas parade, Brooks went on trial for the death of 6 people and injuries to over 60 others, and chose to waive his right to an attorney and conducted his own defense, a move that turned the courtroom into a media spectacle. Throughout the trial, Brooks repeatedly clashed with Judge Jennifer Darrel, made erratic objections, questioned the legitimacy of the court, and was removed from the courtroom multiple times for disruptive behavior. Despite the chaos, the jury found him guilty on every single count, and he was sentenced to multiple life sentences without the possibility of parole. So, no, he didn't really win. Which brings us to the appeal. Now, Brooks originally did have legal representation for his appeal, but last Friday, a court accepted Brooks's attorney's motion to withdraw from representing him in the appeal. This motion was made at Brooks's request. This means Brooks will be responsible for every aspect of his own appeal, researching relevant legal precedents, writing and submitting briefs, meeting all court deadlines, and navigating complex procedural rules. Appellate courts are particularly persnickety about the rules. Each of them even has rules about font size and whether your typeface may be sans serif or not. You don't believe me? Look it up. In his filings, Brooks has hinted at several potential grounds for appeal. These may include claims of judicial bias, violations of his constitutional rights during the trial, or ineffective assistance of counsel before he went pro se. However, many of these issues are very difficult to successfully argue on appeal, especially without the backing of a trained legal professional or even an untrained one. These same arguments in the hands of an emotional basket case of a moron are even trickier. Appeals are not about re-arguing the case or presenting new evidence. They focus strictly on whether technical and precise legal errors were made that affected the outcome of the trial. Unlike a trial where the focus is on presenting evidence and witnesses and, trying to figure out whether a law was actually broken, an appeal is a highly technical legal process. There are strict rules about what issues can be raised, how arguments must be framed, and what deadlines must be met. I should probably save this piece of insight until the end, but Brooks is screwed by being pro se. For Darrell Brooks, choosing to go pro se in his appeal means he must now act as his own appellate attorney. He has to understand and apply legal standards like the standard of review. He has to cite prior case decisions to support his own claims. And he has to follow procedural rules set by the appellate court. Now, if he fails to follow these rules, let me do that again. When he fails to follow these rules, his case could be dismissed without any consideration of the merits of his appeal. This isn't just about passion or personal conviction. It's about navigating a system that demands precision, strategy, and truly deep legal knowledge. Let me explain this in a way that might make it simpler. Many lawyers refuse to appeal outcomes in the cases that they worked on that they don't like, because they themselves don't believe that they have the technical chops to handle the requirements of an appeal. I personally didn't handle an appeal to my state Supreme Court until I had been a licensed attorney for 6 years. And I'm basically a genius and so humble. So why would a person with no apparent precision, strategy, deep legal knowledge, or humility choose to go this route? One possible explanation is control. Throughout his trial, Brooks showed a strong desire to dominate the courtroom, often overriding legal norms in favor of asserting his own narrative. Representing himself may give him a sense of agency in a system he utterly despises and distrusts. Another possibility is that he genuinely believes that he can identify errors in the legal process that a mere court-appointed attorney might overlook or dismiss. Whether or not that belief is grounded in reality, it's not. It could be fueling his determination to stay in charge of his case. He's doomed. Some have speculated that it could even be just a delay tactic or some kind of ego-driven move consistent with the behavior that he displayed during his trial and also during the events that led to his criminal charges. Whatever the reason, this decision aligns with a pattern. Brooks tends to reject external authority and prefers to take matters into his own untalented hands, even when the odds are stacked heavily against him, which they are. Now that Brooks's attorney's motion to withdraw has been accepted by the court, Brooks has been given an extension for the 8th time, not joking, to review all the materials related to his case. Once this extension is up, Brooks will need to submit an appellate brief, which outlines the legal arguments he believes justify overturning his conviction. The state will then have an opportunity to file a response, and they will eviscerate his brief, and Brooks can reply to that response if he chooses, but it's not going to help him. These briefs are crucial. They're the core of the appeal, and they must follow strict formatting, citation, and procedural rules. I wasn't joking about the font, people. It's real. If the court finds that the arguments are substantial enough, it could schedule oral arguments where Brooks would appear virtually or perhaps in person to present his case before a panel of appellate judges. However, many appeals are in fact decided solely on the written briefs. After all arguments are submitted, the court will take time to review the case and issue a written decision. This process can take several months. It can actually take even longer. If the appeal is denied, I did it again. When the appeal is denied, Brooks still has limited options left, such as filing a post-conviction motion or seeking relief in federal court through a habeas corpus petition. Though both of those routes are rarely successful, and they're even more difficult without an attorney or a shirt. Unless a major error is found, the most likely outcome is that his conviction and sentence will be upheld, and as I have said before, he is likely to die in prison. Oral arguments are not the norm on appeal, and definitely not in criminal cases. Appellate courts are famous for their desire to avoid drama and hijinks in their courtroom, and I would speculate that there is a plus or minus 0% chance that they will grant an in-person oral argument for Darrell Brooks. I mean, it's not happening in person. They've seen him shirtless in court one too many times. Sadly, there will be no live stream, but even if they let him come argue, which they won't, the video wouldn't be streamed on the internet, so don't wait for that. What are your thoughts on Brooks' decision to go pro se once again? Are you hoping that he gets mowed down based on his written brief, or would you be looking for a trial part 2 by way of an oral argument? Hey, do me a favor, drop your pro se opinion down below and let me know what you're thinking. And don't forget, while you're down there, to lawyer up with me, America's Attorney, by hitting that subscribe button. Is that how you do it? Hitting the subscribe button? Just hit the button. If you don't, I promise you, I will show up shirtless in your dreams. Why? Do you really hate me that bad? I'll be back soon with another legal breakdown. I'll see you then. Throughout his trial, another possibility is that he genuinely believes and sentence will be upheld, and as a